What to know about death with dignity and voluntary stopping of eating and drinking. This article is based on information published in the Death with Dignity National Center webpage, Wikipedia, and the Washington State Department of Health. It is written by Jim Daly. I'm an 86-year-old man living in a senior co-housing community. The majority of our 40 members are in their 70s and 80s. They are very interested in dying. We talk about it openly and often. We have had various speakers present on death with dignity and the right of voluntary stopping of eating and drinking. Our people want control over how and when they die, and they want it to be rapid and as painless as possible. To that end, my article has two goals. First is to explain the Washington Death with Dignity Act that went into effect on March 5th, 2009, and the recent changes that were signed into law, ESSB 5179, by Governor Inslee, April 6, 2023. The second is to explain and distinguish it from the right of voluntary stopping of eating and drinking. These are two different subjects, though related. One concerns the path to legally qualify for a lethal dose of medicine. The second is concerned with protecting one's rights to stop eating and drinking and to have medical assistance in avoiding the pain or discomfort associated with it. The purpose of both is to have self-control over one's death, to make it as painless as possible, and to make it relatively rapid. The Washington Death with Dignity Act of 2009 allows terminally ill adults seeking to end their life to request lethal doses of medication from medical and osteopathic physicians. Terminally ill patients must be Washington residents who have less than 6 months to live. They must be mentally competent as verified by two physicians. Patients must voluntarily request this procedure without coercion as verified by two physicians. They must be informed of all other options, including palliative and hospice care. There is a 15-day waiting period between the first oral request and a written request. The law requires a 48-hour waiting period between the written request and the writing of the prescription. Two independent witnesses must sign the written request, at least one of whom is not related to the patient or employed by the healthcare facility. The patient can change their mind at any time and rescind the request. This is Washington State Department of Health. Now, the changes, legislation ESSB 5179, passed April 6, 2023, reduces the waiting period between the first oral request to the written request from 15 days to 7 days. It also allows, along with the physicians, the following medical personnel to prescribe the lethal medication: certain registered nurses, registered nurse practitioners, physician assistants, and osteopathic physician assistants. It allows mail delivery of the prescribed medication, and it requires the Department of Health to post the policies of hospitals and hospices. The Death with Dignity Act does not allow for an advance directive that makes it possible for the patient to designate a proxy to request and administer the lethal dose if the patient is no longer mentally competent or physically able to do so. In contrast, we'll consider an alternative end of life procedure, which does allow recognition of an advance directive. Voluntary cessation of eating and drinking. A competent adult has the right to refuse food and drink, even if that person will die as a result. At any time when the patient is competent and they can make an advance directive designating who can decide and under what circumstances they will cease to take in foods or liquids. In this case, even if their body outlives their brain, this advanced directive ensures their wishes will be carried out. Examples of circumstances one might designate to set this process in motion: when I no longer express any recognition of my wife or children, when I consistently move my mouth away from being fed or accepting liquid, when I can no longer speak or react to someone addressing me, when I show signs of long-term pain or discomfort. These are just examples, but the patient can list whatever criteria they want in their advance directive. As far as who, if the patient is no longer competent to make the decision, the advance directive should state something like this. I am, at the time of this directive, of sound mind as witnessed by the two persons listed below, and do designate medical power of attorney to my brother John Seymour Doe. 2, under the conditions I have listed, make all and any medical decisions for me and decisions about the manner and time of my death. If he cannot, I bequeath this power to my close friend, Perry Ronald Hoozit. Check with an attorney for more precise wording and choose someone who is assertive to enforce your directives. Some nursing home personnel may have religious or secular reasons for neglecting these directives. May you have a good life, and when your time comes, a good death. Jim.